Good afternoon. My name is Michael Peabody. I work at the Tarzana office of Bradford and Barthel, and we're enjoying a nice cloudy afternoon here in Southern California. It's been hot, and then it's been cold, and then it's hot, and then cold again. So I, like about everybody else in this area, have been losing my voice. So if I drop out unexpectedly, that's probably why. So I'm very excited to have this opportunity to discuss the post-termination defense. Use it or lose it. I recently had a conversation with an applicant attorney who told me that a judge had told him that there's no such thing as a post-termination defense. And it's true that a lot of people don't understand how this works. Hopefully today we'll be able to discuss kind of how that concept works, why you should apply it when it's applicable, when these situations arise, and how you can actually do it in a way that is successful. I will also be sharing some tips that applicant attorneys give to their clients about how to beat the post-termination defense so that you can be ready for them. So the post-termination defense, use it or lose it. Well, what is the post-termination defense? Labor Code section 3600A gives you a basic roadmap. And rather than dive straight into the statute, I'm just going to give you a bit of a summary about how this works. If you get fired and you later on decide to claim a workers' compensation injury, before you get paid any workers' compensation benefits or your claim is accepted by the court, you have to meet the burden of proof by preponderance of the evidence to prove at least one of four things. Now already what we can see here happening is that there is a presumption that the post-termination defense works in the law. And if you're an applicant who's trying to assert your rights under this, you have to actually be an exception to the rule. And as we'll talk about a little bit later, and you'll see as we proceed, the exceptions are fairly broad. Here's what you have to prove if you want to overcome the post-termination defense. And this is what you have to use in order to overcome the presumption in order to come up with a preponderance of evidence. Okay, first of all, the employer knew about your injury before they fired you or laid you off. Secondly, you have medical records from before you were terminated or laid off that contain evidence of the injury. As we will go into more detail later on in today's presentation, the evidence of injury doesn't necessarily have to show that it was work comp related, but simply that you injured these body parts and sought medical treatment. But then there's two more. The number three is the date of injury was after you were told you would be let go, but before the door shut on your last day. So you give a notice of termination and you actually got injured before you were finally terminated, or the date of injury is subsequent to the notice of layoff or termination. 5411 and 5412 almost sound the same, and we're going to talk about what those differences are because they do come across very similarly. So we'll get into a little bit more detail on that a little bit later. Here's the actual statute, Labor Code section 3600A10. Except for psychiatric injuries governed by subdivision E of section 3208.3, where the claim for compensation is filed after notice of termination or layoff, including voluntary layoff, and the claim is for an injury occurring prior to the time of notice of termination or layoff, no compensation shall be paid unless the employee demonstrates by preponderance of the evidence that one or more of the following conditions apply. So when somebody comes to you and asks you why you're applying the post-termination defense when a judge has told them it doesn't apply, point them to Labor Code section 3600A10, where it says no compensation shall be paid unless the employee demonstrates by a preponderance of the evidence that these conditions apply. And then we get into our four exceptions. Number one, again, this is per the code this time. The employer has notice of the injury as provided under Chapter 2 prior to the notice of termination or layoff. Secondly, the employee's medical records existing prior to the notice of termination or layoff contain evidence of the injury. In other words, it's got to be in the file. You can't come back later on and manufacture it. Third, the date of the injury, as specified in Section 5411, is subsequent to the date of the notice of termination or layoff, but prior to the effective date of the termination or layoff. And D, the date of injury as specified in section 5412 is subsequent to the date of the notice of termination or layoff. Have an accident, and you file a claim, and that's how it goes forward. Labor Code section 3600A continues, and pretty much this has to do with school districts. If you're representing a school district or a teacher, or you have a situation involving that process, it's a bit different because teachers get notices of layoffs in a different way than other people do sometimes, because they can receive a notice of layoff and the school year ends, and there's several months before the actual layoff begins and they're no longer employed. That's what these code sections discuss, and I'd recommend going into those in more detail if you're in that situation or if you're reviewing those issues. But for our purposes today, I'm going to skip over that section having to do with the educational code. So here's what we know. A post-termination is a statutory defense with a clear definition. It does exist. Secondly, it is an affirmative defense that is raised by the defendant. When a person files a claim, you say, this is post-termination. It's a good idea to stick that in your denial as well. Third, the applicant has to overcome the affirmative defense by a preponderance of the evidence. Psych claims, of course, have a different set of rules under Labor Code 3208.3, and I'm going to get into that in more detail later. It's a completely different type of situation, and we'll talk about that. So what is a termination? We're talking post-termination. It's something that occurs after this. So what is the initial termination? Generally, it's defined as any employer-initiated separation. So if you're the employer and you lay off your employee or you terminate your employee, that is a termination. It's different if a person voluntarily resigns their employment or retires, and that's not usually considered termination unless the employee was forced to resign or given a choice to resign or be fired. A lot of times this will come up because you'll have a person who has decided to quit their job and retire or stay home or do something completely different for reasons that you didn't really, as the employer, you didn't encourage it, you didn't ask them to leave or anything. They just simply quit their job. And then they file a workers' compensation claim. You cannot use the post-termination defense against them unless you show that they were pressured to resign or get fired. And the principle of this is that when you have a person who has been discharged from employment against their will, that is a situation where a person may want to retaliate and come after you and sort of get their pound of flesh for the action that you took against them. In this case, where you have a person voluntarily resigning or retiring, and you have a party with them and you give them their gold watch, that is different because you weren't encouraging the person to leave. In fact, you may have preferred that they stayed. There's no retaliation. Therefore, there is no post-termination defense unless you can show that somehow you pressured them to quit anyway. And it's interesting the arguments you sometimes are forced to make when you're in the workers' compensation situation. And if there is evidence to the fact that this person was on their way out anyway, you may be able to raise it, but there's some other complications that can come up with that as well. One thing I should say right now is that I am a workers' compensation defense attorney. I am not an employment attorney. And so when we're talking about termination issues, in addition to the post-termination defense that you may want to raise in a workers' compensation from a work comp perspective, you may also face issues of a 132A claim for wrongful termination if a person claims an injury and then they get fired and then they blame it on the employer for the employer's retaliating against them for filing the claim. You have other issues that can come up. You can have FEHA issues. You can have, Fair Employment and Housing Act issues. You can have EEOC, Americans with Disability actions, all kinds of stuff that can come up. And so the issue, as far as an employer is concerned, may extend well beyond the scope of what we're going to be talking about today. So if you're in the process of trying to address an employee and figure out if you want to keep them or not and how you want to perform the termination when you think they may have a claim in the background, you will want to consult with an employment attorney who is familiar with your organization, is familiar with the laws of the state in which you live, and is familiar with the federal laws and statutes that may work to protect the injured worker against termination. So I'm not going to go into that in too much detail more than that, but I do want to provide that disclaimer and advise you that there is a much broader potential scope of the issue. A termination has to be final or indefinite employment separation. So if you, for instance, have a Christmas tree factory or Christmas tree, you sell Christmas trees or you sell pumpkins or something, and you know that, as of December 26th, the job is going away, then it doesn't count as a termination for purposes of this section. If you plan on, if the person is able to reapply and rehired again when the season starts again, then that is not likely to be post-termination. So let's say they come after you and they file a claim in May after they were laid off and they would be rehired at the end of October. This defense may not apply. You may still have evidence that you did not plan to rehire them, that you may want to apply to the situation, but the courts are going to be taking a hard look at it, and even though you can assert the defense, it is possible that the applicant could demonstrate that they would be rehired and that, in fact, there is no post-termination defense that would be applicable in that case. So the principle behind this is that the clearer the fact of termination is, the clearer the affirmative defense is. If you've terminated a person, it's absolutely clear that they're fired, there's no question about it, then you can raise the affirmative defense with a lot more, you can raise it in a much more capable way where you can argue to the courts that you, in fact, terminated the employee and that they can no longer work there, and the claim that they have filed against you is in retaliation. So what is a termination? Job abandonment. Can you argue that there is tricky, constructive termination? I've had a lot of cases where a person will leave the job and they will go and maybe leave the country for a few weeks, and while they're gone, they get fired just because they weren't at work. And, what do you do in those situations? Or what do you do if the person goes on medical leave and then you pretty much cannot hire them anymore because they've abandoned the job and they've not claimed that the issue is industrial in nature. This often comes up when a person goes on FMLA leave for a personal health reason. And it can be difficult to overcome that and to successfully assert the post-termination defense, because in those situations you have medical evidence that the applicant was injured, and all they need at that point is to have a doctor say that the injury that they sustained was contributed to by the fact that they were working for you. So there are a number of factors in that type of scenario with FMLA leaves and that type of thing, where you're going to want to really delve into the medical history, get into everything, and find out exactly what is going on with the person, because you can actually face a situation where a post-termination defense is difficult to prove up or difficult to prevail on. One of the ways to mitigate the issue of job abandonment is to have a clear directive on absences that is in the employee handbook. And once the person has abandoned their job, you can send a letter to them and tell them, look, you have abandoned your job, you are therefore terminated, and be specific. Put in there, you last worked on such and such a date, we didn't hear from you, I spoke to so-and-so who's your supervisor, we didn't hear from you, and I reached out to you to contact you by telephone, you didn't respond, and therefore, as of such and such a date, you are now terminated. I always recommend that these things go out by certified mail. It's just a much easier way to confirm that somebody received the information. And by the way, the reason why you want to confirm that is, again, to assert that they were actually terminated and that there's a fact of termination. so that you can assert your post-termination defense if they come back with a workers' compensation claim. So what's the difference between 5411 and 5412? They sound almost the same in the statute. The 5411 talks about what happens if the injury happens after the notice of termination or layoff, but before the effective date of the termination or layoff. And the date of injury is the day on which occurred the alleged incident or exposure. That's how the statute reads. So in other words, if you tell a person, hey, I'm going to let you go in 30 days, and they get injured on the 15th day, they trip over something, then, you know, they can actually come back and assert that they were they did not get injured post-termination, and they can overcome the presumption. Again, 5411 and 5412 are exceptions to the general rule. These are things that the applicant is going to want to prove in order to demonstrate by preponderance of the evidence they were injured at work and receive their benefits. So they will argue that they got injured between the time that they were provided the notice of the layoff and when they were actually going to get laid off. The times when this arises is typically when you're dealing with a labor union situation, or there's a handbook issue or something that has a contractual obligation that you provide an employee with a certain amount of time of notice before you actually terminate them or end their contract or lay them off. Both of these statutes were amended in 1973. And 5412 says the date of injury in cases of occupational disease or cumulative injuries is the date upon which the employee first suffered disability from the injury and either knew or in the exercise of reasonable diligence should have known that such disability was caused by his present or prior employment. So 5412, when you get into the language of what it means, comes up when you have a person who, after they've been terminated, suddenly comes to the realization that the injury was caused by something that happened at work. You can have a person who develops a disease, and let's say you terminate a person in 2011, and they worked in a highly toxic environment, and in 2013, they're diagnosed with a disease that resulted from the toxic environment. Let's say they have cancer, for instance. They can come back and say, hey, I didn't know about it when I was terminated. I didn't know about it while I was working there, but now in 2013, I'm disabled because of the cancer. I'm going through treatment, and my doctor told me that it was because of the chemical exposure that I had while I was working in the toxic environment. And that is why I have now claimed my injury. And that is one way the applicants can get around the post-termination defense. Here was a situation in a case called Save Mart Supermarkets versus WCAB. It's a 2007 case. There was an applicant who fell and injured his wrist, but did not report it for 19 months until he needed wrist surgery. The court found that the injury was not barred because he did not seek compensation and had no compensable consequences until he needed wrist surgery. So you have a situation where this guy was injured. He fell and he injured his wrist, but he didn't know he had disability from that until 19 months later. So you can see that this is a fairly broad statute. I mean, obviously you have a person who knew how the injury would have happened, but they didn't suffer disability from it. So there are some broad exceptions to this rule, and that's one of the broadest exceptions to any workers' compensation law, to be honest with you. So how do you line up for these defenses? Or how do you line up to get the defense ready to go? Well, when it comes time to terminate an employee, you know, it's not one of those wait and see what happens situations. You have to make the fact of termination absolutely clear. If you sort of have an understanding with the applicant that you've terminated them, but it's not absolutely clear, like you say, oh, don't come in Monday. That may not work for you. That may not be sufficient to demonstrate that the applicant was actually terminated, because there may be a question in his mind as to what that means. If you say, well, I told them that if they went to Europe to visit their mother, there wouldn't be a job when he got back, so they should have known better. And, you know, when the person comes back, they just don't connect with them again. The person doesn't come back to the work or anything, and they just assume they're terminated. Again, that is not going to be sufficient evidence to substantiate the fact of termination so that you can raise the post-termination defense. And now, again, get an employment attorney involved if you got questions about what you should be doing in these situations, because they're complex and there are more considerations than just the workers' compensation angle when determining whether to let somebody go. Another thing is document everything. When a person is terminated, you may want to have some witness names of people who could testify that the person did not sustain injury while they were working there. You may want to document the performance issues that led to the termination. And you may want to say in there, or should say in there, why the person was fired. As far as the letter you write to the applicant, or well, they're not an applicant at that time. Once the letter you write to terminate somebody, you don't need to go into all kinds of detail like this. But as far as your own records, you want to make sure they're absolutely clear. Keeping good employment histories is a good practice for defending against post-termination claims. And one of the things that applicants like to do is they will say, they can actually turn this entire thing around on you and say that the termination was in fact retaliation because they claimed an injury, even if you didn't know about it, and even if they didn't actually claim it to you. So you want to get your defenses ready before you terminate them. If they claimed any kind of injury, they got medical treatment for an injury before you terminated them, then the post-termination defense is not going to stick. There was a case I heard about a while back. There was an applicant who was a painter, and he was working on a scaffold, and he had an allergic reaction to the paint fumes. And so he decided to get down from the scaffold and sit in the grass and sort of take a break. And his supervisor came over to him and asked him what was wrong, and he said that he was being overcome by the fumes and he was feeling dizzy and he needed to sit down. Well, the next day, the employer came, you know, the guy shows up to work, the employer meets him with a letter signed by all his coworkers saying, you know what, we looked at your situation, you have a horrible reaction to these paint fumes, and therefore you're not safe to be working here and you're fired. Of course, he comes back with a 132A claim and says, no, you fired me because I claimed I was being overcome by injury, that, you know, I was being injured at work, and you terminated me because of my workplace injury. So that's kind of an extreme example, but those things happen, and in that situation, you had an applicant who was able to actually take a termination and use it as a 132A claim against the employer. So you have to be really careful about how you do this, and documenting everything and pretty much demonstrating that there was a clear workers' compensation history, there was not an injury claim filed while they were working there, and these kinds of things will really help you out a lot. Another thing you may want to do is have a separation agreement. Have an employment attorney draft a letter that both parties can sign, if that works, and that indicates that there are no injuries at work in addition to other provisions. So sometimes you can say, look, you know, I'm going to give you a 2-week severance, and they'll help you get over this hump, and in return, I want you to, you know, let me know if you had any injuries, and if you didn't have any injuries, sign this agreement that says you didn't have any. Sometimes, you know, if the person claims that they signed a letter under duress or pressure, they're going to, you know, this letter may not work. So if you just have a separation and you just say, look, you're terminated, I'm not going to give you anything more, but I want you to sign this, otherwise I'm going to call the police, then the applicant will say that, well, this was under duress, and so I therefore did have an injury claim, but I was afraid at the time to admit it. But if you also, you know, say, look, you know, I'm going to give you the severance letter, I'm going to give you 2 weeks of separation money, and once you are, go home, take a look at it, return it within 3 business days, have your lawyer look at it with you, and then when we get your letter back, we'll write you the check. That takes away the duress component and makes it a lot easier for the employer to demonstrate that the applicant was being truthful and honest when they said they were not injured while they were working there. Again, if the applicant comes back in the far future and claims they had a toxic exposure or something, this may not help you too much. But as far as the routine injuries that occur that he would have been aware of or she would have been aware of, the fact that the applicant had a chance to review it with counsel, to take a couple days and look at it, really takes away the sense of duress and should help that document stick a little bit better when we go to court. So actually, my next slide actually discusses sort of what we just went over. Again, try to make it comfortable so that they can't say, well, everything happened so fast and I signed here and there and everything else and I was done. Now, timelines for notifying an employee that they're going to be terminated can vary based on the union contracts and the handbook and other legal obligations. So you're going to want to take a look at what you can do within the structure of your company when you're looking at terminating somebody. We every so often will have an employer who is switching contracts, and you'll have a number of people who are going to be laid off or afraid they're going to be laid off, and we suddenly get tons of claims that are filed between the date of the notice of layoff and the actual layoff. So the law does say that the date of the termination, the actual termination, needs to be within 60 days of the notice of termination. So if you're going to provide that notice and you say, look, I'm going to fire you in 60 days, and then you don't do it, then the post-termination defense is not going to apply. Also, there is a rule, and I'm going to get into, you'll see another slide about it, but if you are an employer and you routinely warn people that they have 60 days until they're laid off, and you never lay them off, that's actually considered a bad faith tactic and can work against you as well. Another thing you can do is make sure, this is while they're still working, make sure that employees understand how to report a workers' compensation injury to an authorized person. Put up a notice in your lunchroom or in the handbook and remind them about meetings where they sign in. You don't need to say, look, this is what we're having a meeting about. Be sure to report your workers' compensation injuries. There's all the power of suggestion. You don't want to get there. But make sure that you have some kind of confirmation that they understand how to report injuries. So they don't say, well, I told my coworker that I got injured and I didn't report to anybody else because I didn't think I had to. Now, you want to make sure that you make it clear to them that they need to officially report an injury and make it easy for them to do so there's no excuse later on. Here's a war story, another war story. There was an applicant who was an account executive for a real estate company, and his boss terminated him. So this guy, and Sam's not his real name, by the way, but his boss said, come back, for your check in an hour or two. So the applicant went out to his car and sat there for about an hour, and then he started to walk back into the building, and while he was walking back into the building, he passed out in the parking lot. So what are the defenses you can raise in that situation? Well, we ended up settling for a nominal amount of his deposition. There's a couple other factors in the case, and it was the wiser decision to resolve at that point. But there could have been 2 major issues there. First of all, he had already been fired as a post-termination claim. Secondly, he wasn't an employee at the time of the injury. So there are a couple of major defenses there. Of course, in this situation, the applicant had received some type of psych treatment before that, and so we thought, well, maybe he could try to tie those things in. But if we hadn't known about that, this would have been a good case to take forward to trial on those 2 defenses. The injury occurred after an effective termination. He was no longer an employee. And the fact that he could come back in to get his check didn't mean he was an employee again. Okay, now we come to post-termination psyche. An applicant is not entitled, and I'm going to quote this from Labor Code section 3208.3E, An applicant is not entitled to compensation for a psych injury claim filed after receipt of notice of termination or layoff and claimed to have occurred before that notice. And here's that word that they love in the workers' comp system in California, unless the employee proves that the actual events of employment were the predominant cause of the injury. That's a 50% standard. Pardon me. And one of the exceptions to the rule applies. The injury was caused by a sudden and extraordinary event of employment. An authorized employer representative was aware of the injury before the notice of termination. Evidence of the psych injury is contained in the medical records in existence prior to the notice, or the trier of fact makes a finding of sexual or racial harassment. So again, these are the exceptions. These are how the applicant is going to prove that he was psychologically injured at work. If an applicant is mugged at work, and then you terminate him, and then he comes back and says, well, I was mugged, and I want a psych claim, then he probably has met one of the exceptions to the post-termination rule, and you'll have to address it on the predominant cause issue and all the other psychiatric defenses. But so you can have this situation. He's, sudden and extraordinary event. Secondly, authorized employer representative was aware of the psych injury before the notice, and this is an issue that the applicant would have to prove by preponderance of the evidence that he provided notice to the employer. This can be done through, documentation or any other types of methods, but it still needs to be a demonstration by the preponderance of the evidence. This is the second exception. Third exception is evidence of the psych injury is contained in the medical records in existence prior to the notice of termination. So if the applicant went to the doctor and said, I've got headaches, or I've got, depression or anxiety, and this is going on, and maybe some medications were prescribed or something, the applicant may be able to demonstrate that that was also part of a pre-termination notification, or at least not notification, but pre-termination evidence. Or fourth, the trier of fact, or the WCAB judge, finds that the applicant was sexually or racially harassed. This one comes up every so often, and employers will look at it and say, well, my applicant did not report the harassment while they were working there, and therefore, after they were terminated, they filed a claim, and therefore the post-termination defense applies. But if a judge says, look, they were afraid to report it while it was happening, but they were sexually harassed every day at work, and therefore, the post-termination defense does not apply. So that can be a significant issue, and one worth making a special note of. If an employee is being sexually or racially harassed at work, they can come back and claim psych even if they get fired. Fifth one, the applicant's date of injury was after notice of termination or layoff, but before the effective date of termination or layoff. Post-termination psychiatric cumulative trauma claims can be barred even though a post-termination physical injury CT claim may still be pursued. So if you have a psych claim that's mixed with an ortho claim, and these are decreasing in frequency after SB 863, but if you have the situation come up, you can actually argue separately that the psych is not a valid complaint and is not active, even though the applicant may prevail on the ortho injury claims. So you're going to want to make sure that if you're trying the issue before the trier of fact, that you bifurcate the orthopedic from the psychiatric issues, and you make it very clear to the court that you would like the court to make the psychiatric analysis rather than the orthopedic analysis apply to the psych portion of the case. If an employer can prove, and this is a good faith personnel action defense, if an employer can prove that the applicant's psych injury was substantially caused, that's 35% of the psych injury, by a good faith personnel action, like a legitimate layoff or termination, the claim may be barred. And that could be also another personnel action that happened before that, such as a written warning or something else. Every so often these cases come up, a person's terminated and then they go to the doctor and the doctor says, this person, or psychiatrist, the psychiatrist writes a report saying, this person is very depressed and has all these psychiatric symptoms because of how they were treated when they were terminated. They were told to clear out their desk and they were escorted out by security, and that was damaging to their psyche, and therefore they have a workers' compensation claim. You can argue that this was a good faith personnel action and that there really was no other way to do it. So the court will take that evidence into account, and you're going to want to argue that the psych portions that the applicant is claiming were substantially caused by good faith personnel action. And where does this 35% figure come from? I want to make sure that this is highlighted because this should be identified in any psych case that you're taking forward. For purposes, and this I'm going to read directly from 3208.3b3. For the purposes of this section, substantial cause means at least 35 to 40% of the causation from all sources combined. Okay, that was 35 to 40% of the causation from all the different psychiatric factors was part of a good faith personnel action. So it's right there in the code, and you want the doctor, a psychiatrist, to write a report finding that at least 35 to 40% of the applicant's psychiatric claim was caused by the good faith personnel action. This is done in the form of what they call a ROLDA analysis, where the psychiatrist is asked to identify the various stressors in the applicant's life and assign a percentage of apportionment to each one of those. And then when you add them together, you want to make sure that the good faith personnel defense is occupying a 35 to 40% amount of that. And you may want to also push that to the 50% limit if there's no good faith personnel defense, and that way you can actually wipe out a psych claim completely. But these are not as easy as it sounds, because doctors will oftentimes write reports in such a way as to avoid this situation and to give the applicant the benefit of the doubt that the injury was in fact industrial in nature. So sometimes this requires a very strong factual analysis and a cross-examination of the doctor. And if the doctor does not issue the proper apportionment guidelines, you may need to move to strike the doctor as not substantial medical evidence, or otherwise demonstrate to the court that the applicant's psychiatric disability was predominantly caused by work, or substantially caused by, predominantly not caused by work, and the substantial portion was the good faith personnel action. So that's a tricky issue that's not quite as easy as it sounds, but something to pay attention to. So why is it harder for applicants to prove a psych claim after they get terminated than it is to prove an orthopedic claim? Well, the legislature actually was very clear, and this is another section if you're writing a trial brief or you're writing a appellate brief on this issue. You want to include Labor Code section 3208.3c, which states, it is the intent of the legislature in enacting this section to establish a new and higher threshold of compensability for psychiatric injury under this division. It's right there in the code. So when can you use it? Well, let's say you have a situation where all you really knew was that the employees were talking about a possible rumor of a layoff or termination. You may want to argue that there was a constructive notice of termination, and that that the applicant was aware that termination was happening, and that the claim was filed in retaliation for that notice of termination. This is going to be it's a very fact-specific situation, and obviously if you're not able to prove it, you're not able to prove it. But if it's possible to demonstrate this rumor or discussion, then you want to use that to your advantage. A good faith personnel action is not the same as a post-term defense, since that can apply to any good faith personnel action. So you can use good faith personnel action in a lot of different scenarios that are not necessarily post-termination. It just has to be some kind of personnel action. So here's how you use it. Once you can show that 35 to 40% of the psych issue is due to the good faith personnel action, the employer can prove the actual events of employment were none. You can then prove, or move forward to try to prove, that the actual events of employment were non-discriminatory and in good faith. Here's parts of a good defense when you're dealing with a good faith personnel action. You need to have a good employer witness. If you don't have an employer witness to testify as to the reason why the applicant was terminated, it's going to be very difficult to prevail on that issue. And in fact, a good employer witness is necessary in any post-termination complaint to demonstrate that the applicant did not report any injuries, or to testify as to the process for reporting the injuries so that you can then demonstrate that the applicant did not follow those steps. And in the context of a good faith personnel action, you also want to show the action was following a pre-existing written policy, such as the employee handbook, or was part of a seniority or merit system. And we talked about this before, but this can sometimes have some interplay with the 132A action, which may require similar defense. And sometimes if you do the research on one of these, you will also have the research for the 132A. Demonstrating business necessity is a decision due to things other than the fact that the employee filed a work comp claim, and the employer could not reasonably accommodate the employee's disability, things like that. Employers who are concerned, again, about a potential 132A claim should consult with their employment law counsel before taking employment action. So we talked about some of the defenses to this. Now I'm going to kind of flip it a little bit and talk about what applicant attorneys tell their clients about how to avoid the post-termination defense. And this is from an article about 11 years old from Work Comp Central called Steps to Avoid the Post-Termination Defense. Here's what they tell the applicant. If you get hurt, see a doctor no matter how minor you think it is, and keep the doctor's bill or other documentation. These are things that can be used against the employer in these kind of situations. Secondly, be sure to demand a claim form from your employer. They can't deny you a claim form, and it's not up to them to decide whether you got hurt. If they don't give you the claim form, document the fact in a memo to them. So if they get injured and they go to the employer does not provide a form, they should write a letter to the employer saying, hey, I asked you for a form. I told you I got hurt. I hurt my left wrist and my arm and my back, and you told me I couldn't have a form. That can be a very damaging correspondence to an employer, as you can imagine. Third, they tell the applicant, think of other evidence that will aid in substantiating your claims, such as phone records. Did you call somebody? Write down the names of witnesses to the accident or the reporting of the accident who can testify later. So people who either saw the accident happen or heard you report it. Make sure you have their names. You know, it's interesting as a defense counsel, when I take a deposition of an applicant and I ask them the names of the witnesses, a lot of times they have no idea who the witnesses were to the incident. And they'll give me a name or a nickname or something, but they don't have specific information. If an applicant was truly proactive and followed these steps, it would be very difficult to maintain a good faith or a post-termination defense. So that's why these issues or these recommendations are given to the applicants. And then finally, the recommendation from Work Comp Central was, when in doubt, hire a lawyer. Documentation is your friend. So applicants who want to maintain a post-termination defense have to think about it ahead of time, have to go through some steps to substantiate that they had some kind of an injury or they told somebody about it and that they wanted to report it. And if they have all this stuff in a row, they will have a good chance of prevailing. But usually, most applicants don't think about the possibility of filing a post-termination defense until they actually have employment action such as the termination. Okay. If an employer gives notice of, I wanted to talk real briefly about the 60-day rule. If an employer gives notice of termination or layoff but doesn't follow up within 60 days, it doesn't count. If employers try to get around this by frequently providing notice without actually acting on it, it can be considered a bad faith personnel action, in which case the post-termination defense will not apply. As we close, I'll go over a couple of different cases that have occurred regarding this issue. Okay. If notice of injury happened at the same time as the notice of termination, the injury is not barred by Labor Code 3600A10. So if an applicant claims something that happened right at the moment that they get fired, the defense is not going to help you. If the applicant reports an injury to a union rep, that doesn't count. This is an interesting case called the Metal case, Charter Communications versus WCAB Metal, 2014. An employee was told that he was going to be terminated because he was seen speeding in a company vehicle. So the employer sent another driver to bring this guy back home, 50 miles, and so the other driver of the vehicle driving the soon-to-be injured worker passed out and hit a large tree, injuring the person who had been speeding originally. The court found that even though he was going to be fired anyway, the post-termination defense did not apply since he was still an employee at the time of the accident. So yeah, he knew he was going to be fired, but he was sitting in he was still within the company control and he hadn't yet been fired. The Labor Code only requires evidence of an injury, not that it was medically addressed as a workers' comp injury. So if an applicant goes and treats privately with their own doctor and says, hey, my back hurts, I don't know why, and then they later come back and claim that was a industrial injury after they get fired, that may still be sufficient evidence that the applicant did seek medical treatment, and it may overcome the defense. Once the post-termination defense is raised, then the applicant has the burden of proving one of the exceptions by a preponderance of the evidence. If the applicant does not put on a case, the defendant should argue that the applicant failed to meet its burden of proof. So when you're dealing with the issue, make sure that you are constantly aware for your own benefit of the fact that the applicant has the burden of proof, and as you're litigating the issue, treat it as if the applicant is really having to prove that portion up and contest that issue with them. And by the way, treatment to the same region of the body, the court said in this case, was not the same as an injury. So here's a summary. A post-termination defense will work unless the employer has notice of the injury, there is a medical record existing prior to the notice of termination, the date of injury was after the notice of termination or layoff, but before the actual termination or layoff, and the date of injury was after the notice of termination, but he found out about an old injury later on, and injury plus knowledge equals a new date of injury. So that can, those are the defenses. Strategy: raise the post-termination defense early and often. Get witnesses, documents, and other evidence in order. At deposition and in discovery, confirm dates of injury and knowledge. Subpoena records, and prepare to litigate the issue. That's the presentation. I understand there are a couple of questions here today.
Hi, Michael. Thank you so much. Yes, we do have a few questions. Let's start with, what if the employee quits and later tries to come back, but there is no job for him or her, and she files a claim?
That's a good question, because we have a situation where there was no clear notice of termination. There's no clear evidence of termination. The applicant kind of quit on their own, and then they tried to come back, meaning that the door was open for them, and they were told that there was no job for them. If the door is open and if they're told, it has to really do with the second part of this. They're told that there's no job for them. Is that a termination to stop trying, or are they telling them, look, I don't have anything for you right now, but you can come back later on? If it's not a final action of termination, I would anticipate that the applicant attorney would say, look, the applicant left on good terms before, they were still welcome back, there was no real evidence of termination, so therefore the post-termination defense does not apply. What the employer will want to demonstrate is that, in fact, the applicant may have quit under pressure. They were given a bad performance review and they got mad and they said, I quit. Or they were told that they would either have to quit or be fired, and that when they came back for a job, the employer would have been crazy to bring them back because they were such a bad employee, and that there was no real, there was no possibility the person could come back. So if it was one of those situations where it's almost like a seasonal employee or that there was a slowdown in business, it's going to be hard to prove. But if it was final, then it's going to be a lot more easy to raise the post-termination defense.
Okay, great. Next question. If you are in the process of downsizing a department, can you include a separation agreement in the severance document?
Well, this speaks to an issue in employment law, and it really depends on what your handbook says and whether there are union rules involved. But if you're downsizing a department and this is a permanent layoff, and the intent is that if a person wants to continue working there, they're going to have to reapply in the future, but you're pretty much done with them. I mean, the case is, their employment is over. You can include a separation agreement in the severance document and say, look, take this home, have your attorney look at it. If you want, you're welcome to have your lawyer look at it. Send it back to me in a couple of days, and once we have it, we'll issue your severance check. You can usually do that, but again, I'd be cautious only because I don't know all the exact facts of that situation.
Okay. Thank you. Next question. Is notice the date of the written notice, or could it also be the date of an informed rumor?
Okay, well, I like the term informed rumor. I don't know if that, it's kind of did the person know from somebody knowledgeable that the layoff would happen? What you want to do is, how close to it was the date of the actual termination? When was the actual termination planned for? And how close in time was that? If a person, chances are, what would happen is the applicant would say, hey, look, there wasn't a post-termination because I wasn't actually informed too much that I would actually be terminated. It was a sort of rumor that was floating around, and therefore it's not post-termination, or it doesn't apply to that 60-day rule. It's very fact-specific, and an informed rule, I would argue as a defendant, I would say, look, if the termination had in fact been planned and it was going to take place within 60 days that the rumor hit, I would argue post-termination, but it would be very fact-specific and it may be a difficult one to prevail on. It's better to have an actual notice. And one of the things that you may want to emphasize in these situations is that it's not a good idea to be spreading rumors about terminations unless they're actually going to happen. Judges tend to look poorly upon that, as it can be used as, can be considered a bad faith tactic if people are constantly reminded they're going to be terminated within a certain amount of time and it doesn't happen. So the rumor mill is a bad idea in general, but again, very fact specific.
Okay, great. For psych, what if the CT period injury occurs within 6 months of the date of hire and the employee is terminated after 5 months?
That's a good question. The 6-month rule on 3208.3 typically bars psychiatric disability claims unless you have a sudden and extraordinary event of employment or another factor applies. Assuming that this is just a routine psych claim where a person says, hey, I got stressed out at work, it was too hard for me, it gave me bad dreams, I think there would be a very good argument that the applicant was not working for the 6 months and therefore the claim wouldn't stick. Under SB 863, of course, psychiatric injury claims pretty much have to stand on their own. You don't see a lot of claims being allowed for orthopedic sequelae unless there are very specific exceptions to the rule.
Okay, thank you. We have a few more questions and we still have a few minutes left, so I'm going to keep going if that's okay.
That's okay.
If the labor code only requires evidence of an injury to get rid of the post-termination defense, can the claim then be put on a 90-day delay of status?
Obviously, you can always put a claim on a 90-day delay, but you want to move quickly on a post-termination defense. And if it looks like the claim should be not denied, you may want to move quicker on that, provided that you have that kind of an evidence in place. So yeah, I think you can still put out a 90-day waiting list or a 90-day delay. See what happens.
Okay. If the QME finds that medically there is evidence of a CT prior to termination, ortho, but does point out that are issues with the reporting and evidence shows claim reported post-termination, how strong will the defense be?
Okay. So this is a situation where you have an applicant who didn't, I'm assuming this is one where the evidence came up after the fact. So you have a QME after the termination comes back and says, hey, I think there was a CT that happened then, but there's no evidence that it happened contemporaneously with the employment. There's or that the applicant reported that while they were still working there. This may fall under a 5412 situation where you would have a applicant coming back later on and claiming that they only recently found out about it. But what you want to do is in deposition and at trial, get the applicant to testify as to when they first began experiencing pain from that situation, or when they first began, realizing that they've been injured at work. Because, if they say, hey, look, I realized it while I was working there, but I didn't do anything about it, then you go back to the reporting requirements. There needs to be medical evidence that arises within the employment. On the other hand, if the applicant comes back and has some kind of weird situation where they didn't know about it while they were working but only found out after the fact, they can have a stronger claim. So what I would recommend is go over the facts of the case very specifically, get witness statements, get information from employer witnesses who can back you up that the applicant did not file a claim and that they were terminated and that they have only now pursued that issue because of retaliation. It's fact specific. It's not a perfect scenario, but it's certainly not an impossible situation to overcome. And I would certainly put the burden of proof on the applicant to raise the exception to the rule.
Okay, great. Most defense attorneys recommend a QME, but if there is no evidence to support a post-term CT claim, why go to a QME?
That's a good question. I think, a lot of people say, look, you need to get some medical evidence in the case. And a lot of judges really like to have that evidence. But the reality is, if you have an applicant who's going to go to a doctor, there's a 50-50 chance the doctor will find injury. And they'll, especially if the applicant claims that they have, tenderness or some kind of other evidence of injury that you cannot really objectively prove. So if you have a situation of a post-termination defense, file a DOR on AOE/COE on the post-termination defense and take it to trial and make the applicant prove up that they had reported the injury or that they have some one of those 4 exceptions to the rule. Otherwise, if they can't meet those exceptions to the rule, they're barred from pursuing the post-termination defense. So you don't have to go to a QME in order to prevail on this issue.
Unfortunately, we're out of time. We do have a few questions that we didn't get to, and I will go ahead and email those over to Michael and have him answer you back via email. Thank you very much for attending today. Have a great day, everyone.